Well, good afternoon. I'm Hank Hyatt, Vice President of Economic Competitiveness for the Greenville Chamber. I would like to welcome you to our second Rules of Business webinar presented to you in partnership with Ogletree Deacons. The Greenville Chamber strives to provide value to our investors. Our vision is a globally competitive upstate economy where businesses succeed and people prosper. That and our tagline, "Let's do something that matters today," are alive and well in this room. The Greenville Chamber is a strong advocate for pro-business legislation and works with 10 upstate chambers and business leaders to set legislative priorities annually. We are currently 2,200 members strong, positioning us as the most influential business organization in the upstate. We've taken the lead on educating our business community on the new Fair Labor Standards Act overtime regulations because they require sweeping changes that affect almost every business in the upstate. Given recent developments, we're back again today to provide updates on the current status and possible future scenarios for the FLSA regulations. We're very pleased that Chuck McDonald, shareholder with Ogletree Deacons and specialist in labor and employment law, is with us today to provide his insight on this situation. I'll hand it over to Chuck.
Thank you very much. Well, good morning or afternoon, depending on how you want to look at it. I think we just crossed the noon hour. Going to give an update on the FLSA regs, which unless you've had your head under a rock, you should know about and should have been dealing with for the past several months. I did want to start briefly just by letting y'all know that we have everybody muted. If you have questions, I will take them at the end, and if you can, type them into the little chat function, and we'll answer your questions as we go along or after we do the program. I've only got it scheduled for about 30 minutes because I didn't really think it'd take that long to give y'all an update. I wanted to let y'all know what the current status is, what most, or at least what the majority of our clients have been doing ever since the injunction came down, and then let you know what we anticipate happening over the next couple months, and maybe it'll help you be able to plan better for your business. I'm going to start. I got a couple of PowerPoints, not many. I think we got 3 or 4, but as y'all know, there were 2 separate cases filed in Federal District Court of the Eastern District of Texas. They were filed in the Eastern District of Texas because they thought they could find a more favorable judge down there. They ended up getting the same judge that heard the persuader rules, for those of y'all who are familiar with that and how that impact on the National Labor Relations Act. And so that's why it was filed there in Texas. The cases were consolidated in October. A hearing on the plaintiff state's emergency motion for preliminary injunction was heard on November 16th. And so what you have to have in order to have an injunction is you've got to be able to meet 4 thresholds. And again, what a lot of people don't understand is you just don't go in court and file an injunction. I mean, you do, but you're actually filing a lawsuit. So there is a pending lawsuit with a complaint and an answer to the complaint and everything else in addition to the motion for injunction. But, of course, that's what everybody's focusing on for purposes of the implementation of these new final regs. So they had a hearing in November, and then the judge had to determine whether there was substantial likelihood of success on the merits that the plaintiffs would win. There's a threat of irreparable harm to the plaintiffs. Injury to the plaintiffs outweighed the potential damage, and the injunction would not dissolve or deserve public interest. What you've got at the end of the day is the judge went through this legal analysis, but when you read through it all, what the judge really said and the arguments the states made was that by increasing the minimum salary more than double, that what the Department of Labor essentially did was eviscerate the primary duty test. The primary duty test is in the statute, and that by increasing the salary test so high that you essentially eliminated the primary duty test, the argument that the states are making is that the Department of Labor exceeded its regulatory authority because it essentially took away part of the law that is that Congress passed. Now, the arguments the state had, and this is what's real interesting about the injunction. The injunction, is applicable to all businesses, public and private. But the states had a better argument, in my opinion at least, on the immediate irreparable harm and meeting these actual factors, if you will, because the states were arguing that, hey, we only have set amount of budgets, we only have set amount that we can operate in, and if we have to comply with these new regs and increase people's salary or absorb this additional overtime, we're going to have cut certain funding and certain state programs are going to be gone. That was the argument the state made, which is a fairly compelling argument from the irreparable harm standpoint, but it's really only applicable to states. Now, business can say they got budgets too and this and that, but they're not offering the same kind of services, as a state is through its public agency. So the judge heard all that. Judge issued the injunction. And so what the injunction did is it preliminarily barred or halted the implementation of the final overtime regulations that all of our clients and employers and chamber members have been working on to try to get in compliance by December 1. Depending on your views on it, you can either think it's a good thing or a bad thing, but what I think everybody can agree on that it was frustrating, the timing is very frustrating because people had spent a lot of time and money. A lot of employers had already made the switch or made the changes in light of the December 1 deadline, and, right before we get there, November 22nd injunction now is passed, put into place that makes the implementation of the final regulations no longer applicable. So that's where we are. I think, now I want to talk about what's happened over the last couple of weeks and what we can expect, over the next month or two. So the DOL has appealed to the Fifth Circuit, which was anticipated. Anytime there is an injunction, that is a final appealable order because you're prohibiting the implementation of regulations or whatever it is you're seeking to enjoin. The Fifth Circuit, as we speculated, could expedite it, but given the time period of Trump's inauguration and all, there's only so much they could expedite unless they were going to issue a decision either without briefing or unless they were just going to have an oral argument or something. Well, there were motions filed to expedite the process. Department of Labor filed motions to expedite the process. However, even the Department of Labor recognized that in order to really brief everything, you got to give enough time to brief. You got the holidays, and then they anticipated that amicus briefs might be filed. So the states opposed the expedited motion. The court granted it but modified the dates. But when you look at the dates, you still have a reply brief due on January 31st. Even the amicus briefs are due January 24th, which is 4 days after the inauguration. So, based on this, there appears to be absolutely no way that you're going to have any decision from the Fifth Circuit before Trump's inauguration. And I do think that's important because that means that regardless of what the Fifth Circuit does, you could even have congressional action or the Trump administration either trying to do something or put something in place before the Fifth Circuit even has an opportunity to make a decision. I speculated along with some other lawyers that the Fifth Circuit probably doesn't really want to touch this and would prefer to just let the new administration deal with it. From a timing standpoint, I think they're likely going to have that opportunity. This is when the briefing ends. This doesn't have anything to do when the Fifth Circuit has to make a decision. So those of y'all who have had cases appealed to a court of appeals know usually they're several months after you have briefing and or an oral argument. And because of the significance of this injunction, I got to believe the Fifth Circuit would probably grant an oral argument. But we'll have to wait and see where the end of that really happens because once the Trump administration is in place, the Department of Labor could simply withdraw its appeal, which is very possible, a very possible situation that may occur. But because of the current briefing schedule, what we've been telling clients is we don't really expect any change. We don't expect the injunction to be overturned. We basically expect the status quo to be maintained through January 20th. And after January 20th, we'll see where we are. Okay? So with that in mind, what other options are there? What else could happen? Well, there's several things that could happen. One is, like I said, the Trump administration and the new Department of Labor, head of the Department of Labor, could simply withdraw the appeal. And I can assure you if the appeal gets withdrawn, anytime an appeal is withdrawn, the Fifth Circuit is not going to say, oh, no, we really want to rule on it. They will say thank you very much and move on to the next thing they have on their docket. So that's a possibility. The other is you could try to get some kind of other kind of administration through the Trump administration, whether it's new Department of Labor regulations. We could get things as simple as Department of Labor saying regardless of what the Fifth Circuit or District Court in Texas does, Department of Labor is not going to enforce these new regs. Now, that wouldn't help against a private lawsuit if the injunction was ever lifted. But, you know, the Trump administration or the new Department of Labor could say, you know, we're not going to enforce these new regs. We don't believe them. They weren't administered. We think they were improper, et cetera, et cetera, et cetera. Because it's not an executive order, Trump can't come in on day one and immediately just sign something that'll wipe it out, because it's not an executive order. But what he could do, or what Congress could do, is use the Congressional Review Act. And you would have had to go on to law school or been a legal geek to even know what this was until this situation presented itself. This was a law that was passed, I think, back in the 90s, and it's only been used once, to my knowledge. It was used by President Bush to rescind some regulations that came down from OSHA on ergonomics. And what this law basically says is that, you know, it gives Congress the right to go back and nullify any administrative regulations that were issued within the last 60 days of the congressional session when a president is rotating out of office. Okay, so what's interesting about that is a lot of people would think, well, it's been a lot more than 60 days, but when you do congressional days, that means days they're actually in office in session. So actually May 20th, the 60th day, was Friday, December 9th. We're still trying to confirm. You wouldn't think it'd be that hard to figure out, but my understanding is the House has recessed for the year. So by doing that, only one part of Congress had to recess to trigger the ability to use this Congressional Review Act. So a lot of people are suspecting that Congress, because we got a Republican Congress now, is going to use this Congressional Review Act. And there's two important things on this. It wouldn't happen immediately, but you would know if it's in process, because Congress will come back in early January, even before Trump's nomination, and they will have the ability, if they want, to pass a law. It's essentially a law to nullify either specifically this overtime regulation or any regulation that was, was finalized within the last 60 days of the last congressional session. The important thing about that is not only would that rescind the regs, but the way that statute, the Congressional Review Act, is written is it also prohibits that agency, and this applies to any federal government agency, from passing a substantially similar regulation. So what that means is the DOL couldn't go back. Now, under Trump, it probably wouldn't happen anyway. The DOL couldn't go back, write a new final reg and send it back through the administrative process if it's substantially similar to what you had before. What that means is, and what some congressmen have said is, that Congress is the one who will now take this on. And Congress has a lot of things they can do. They can pass a law that sets a minimum salary. They can pass a law wiping the minimum salary out. They could pass a law saying the minimum salary will be set by the DOL, but it can't be anything further more than 10% of what it was previously. I mean, there's all kind of options on the table with what Congress could do. But what this Congressional Review Act would be able to do is to essentially nullify the final regs for good, put a death nail in them, if you will. If they did that, that would make the lawsuits at the district court moot. It would make the Fifth Circuit appeal moot, because nobody's going to hear an issue that doesn't have standing anymore, so those would now be moot. And then it would either be up to Congress to pass some kind of law at some point on this, or the DOL could go back and amend some regs, but they'd have to make sure they do it in such a way they don't, violate the Congressional Review Act. So a lot of people are speculating that Congress and Trump that there are discussions about what's going to happen with this final regulation, but if they access this Congressional Review Act and they use this, they could nullify these regulations. And that's going to lead me into my final point, which is the reason I think that is significant is I think employers should maintain the status quo currently. Whatever you have done, if you made changes in anticipation of December 1 and you've already made them, our recommendation as a firm has been just stay where you are. Keep the new salaries or the changes there for now and wait a month or two and let's see how this plays out. it's unlikely that the Trump administration or Congress will do nothing for, a month or two, but it's very possible if they don't enact this Congressional Review Act and don't use that legislation to nullify the law, the implementation of the new regs, if they just waited and wanted to pass a bill or something, the problem you could have is the Fifth Circuit could then end up being in a situation where they had to make a decision, and if they overturn the injunction, then you could have a situation where we might have a month or two period where the new regs would be applicable. And so employers who've already made the change, you don't want to change it back and then have to go change again. You don't want to have to make 3 changes in the next 2 or 3 months. So that's why our recommendation has been to maintain the status quo, regardless of whether you put a halt to your proposed changes or whether you already made the change. Because if you put a halt to your proposed changes, it's very possible that you want to wait it out and see what change is going to be made anyway. Let's assume even if the Trump administration ends up nullifying or wiping out these final regs and they're gone for good, still doesn't mean that there may not be some change to the minimum salary, because a lot of people still believe it's way too low. So I think it's worth waiting to see, what the landscape looks like, if you will, in 2017, because I think certainly by mid-February, I think that there will be enough out there that we will have a sense of what the administration is going to do with these overtime regs. You're either going to already see the Congressional Review Act being implemented, because there'll be legislation going through the House and or Senate to nullify these regulations, or you're going to see some announcement from the Trump administration with a plan they have. I think something is going to happen so that we will know. So my point is, I don't see there's no real reason to make a change between now and January 20th. It's probably worth holding your status quo, seeing what the new administration does, seeing what we're hearing from the new administration once they're in, and we'll get a sense pretty quick what their plan is and how high the overtime regs sit on their priority list. I think they're pretty high, but we also know the ACA is high and some other things, so we have to see where, this really falls in. But from what our sources in Washington, D.C. and the lobbyists we're hearing from, the intent was to at least go ahead and suspend the session in enough time to have the Congressional Review Act on the table if they want to go there when they come back in January. So kind of to recap real fast, and then we'll see if we have some questions that y'all have that I haven't addressed. We've got the injunction for currently as the law stands, the current $4.55 minimum salary is in place. The new regulations have not taken effect. That injunction we do not believe will be lifted or stayed between now and the end of the year, or even between January 20th, because we've got a briefing schedule now with the appeal in the Fifth Circuit, and it's going to take us past that January 20th deadline. There is this possibility of a Congressional Review Act, which could end up just nullifying these regs, final, if you will. It'd have to go through both houses and both sets of Congress, Senate, and the House, and get signed by Trump. But still, if they want to expedite the process, they could do that in 35 or 40 days. And if they're doing that, and that's going through the channels, everybody's going to be talking about it and reporting it. And so we'll have a sense of what's going on, I think, by the end of January or early February. So that's why our recommendation is, if you made the change, go ahead and stay where you are. If you didn't make the change, go ahead and hold tight and see what happens. I think that's the best advice I can give. And just like I said, I think by early February, we'll have some sense of what's likely to happen with these final regs. With that, I appreciate everybody's time. I may have been a little quick, but we only set 30 minutes because I didn't really think it'd take that long. But if anybody has any questions, they could type them into the chat box. Or we can open up the phone lines, because we know some people may have only been calling in and may not be participating through the webinar. So we'll open up the phone lines, and if anybody has any questions, I'll be glad to answer them. We don't have one brave soul out there.
If it doesn't get rescinded, will people that did not change have to go back and repay over time?
Well, no, but there are some people who have argued that's a possibility, but I think it's very minor. Once an injunction is put in place, it's not intended to be retroactive. So I think everybody is fine. The only thing I will say is if they're not rescinded and the Fifth Circuit does go ahead and hear the appeal and make a decision, you better be ready to move, because the Fifth Circuit, the Fifth Circuit is not going to say you get 30 days. They don't really have, the Fifth Circuit would just say the injunction was inappropriate, they didn't meet the 4 factors for injunctive relief, and the injunction is lifted. And as soon as the injunction is lifted, unless Congress or Trump have done anything else to nullify those regs, they would immediately become applicable. And at that point, you would have to start paying the $9.13 a week. And if that happens, I'll be honest with you, I'll have to see. I still don't think it'd be before February or even March, and I think by then we'll have a better sense of what the Trump administration is going to do with these regs. And even if the injunction is lifted, depending on your particular business, you might want to just maintain that. You might just want to raise the salary for everybody to $9.13 a week, because you may only be doing it for a couple of weeks or a month until something else happens. Or you may want to convert them. What you may be doing is just temporary. So again, I can't answer it for each business, because it may vary depending on how much money you're talking about, how much of an increase, and how many jobs you have, and how many non-exempt and exempt people we're talking about. But there's a possibility that the Fifth Circuit, basically reverses the injunction. That once an injunction is lifted, then it's immediately the law. So, but I still don't anticipate that happening before January 20th. Based on the briefing schedule. And I'm not sure I've ever seen a Court of Appeals make a decision in the middle of a briefing schedule. I mean, they would certainly not without a hearing or something, because you got to brief the issues. The Fifth Circuit, they got to go through the process. So that's the only thing I would say be looking for.
So any other questions from the audience, participants? If not, I'd like to first say this is fascinating stuff. So thank you, Chuck.
You're welcome. Thank you all for participating.
We appreciate his expertise, and know our listeners have as well. We're going to be posting a link to this recording in the coming days, so be on the lookout for the Chamber's weekly update email, which will include a link to the webinar recording, FLSA updates, and notifications of upcoming Rules of Business webinars. On behalf of the Greenville Chamber and Oakland Deacons, thank you for joining us. Enjoy the rest of your afternoon, and happy holidays.
Thank you.